For a solicitor to provide effective legal advice, they require access to every relevant fact about a client's situation. This reliance on total disclosure is only possible if the client is certain that their information will not be released to the public. Paragraph 6.3 creates a duty to keep the affairs of current and former clients confidential. However, paragraph 6.4 introduces an opposing obligation. A solicitor must make a client aware of all material information. These rules clash when confidential information becomes highly relevant to another client. In this situation, the solicitor is simultaneously prohibited from communicating the data and required to disclose it. Resolving this involves a specific regulatory framework that dictates when the duty to keep a secret must prevail over the duty to inform a client. Paragraph 6.3 is wide in scope. It applies to all information about a client or a matter, whether that information is commercially sensitive or entirely routine, and regardless of whether it came from the client or a third party. The duty continues after a matter concludes, remaining in effect even after the retainer has been terminated or the client has died. Specific instances require this confidentiality to be set aside, such as statutory duties to HMRC or under anti-terrorism legislation. The SRA also mitigates breaches for preventing serious self-harm, protecting children from abuse, or preventing a criminal act likely to cause serious harm. Notably, if a solicitor is being used by a client to perpetrate a fraud or any other crime, the duty of confidentiality does not arise in the first place. Outside of these legal requirements or the client's express consent, the solicitor cannot communicate the information or make use of it for other purposes. Under paragraph 6.4, the flow of information to a current client is mandatory. You must disclose everything material to their specific legal matter. This duty is personal, triggered by your individual knowledge, not the firm's collective information. Disclosure is exempted if prohibited by national security, if it causes physical injury, or if the client gives informed written consent. The fourth exception addresses privileged documents that a solicitor only knows about because they were disclosed by mistake. Following Applet v. Mills and Reeve, if you receive a misaddressed document intended for the opposing party, you must return it immediately without reading it. In this scenario, you are not required to disclose the contents of that document to your own client. This ensures that a procedural error by one firm doesn't create a mandatory disclosure obligation for the solicitor who receives it. To see how these rules interact in practice, consider a solicitor named Jacob. He previously acted for Amy when she sold a plot of land. Now he is instructed by Sam, who wants to buy that same land to build a house. Jacob knows from Amy that the land is contaminated, owing her a continuing duty of confidentiality. Simultaneously, Sam needs this information, triggering Jacob's duty of disclosure. Jacob cannot inform Sam without breaching Amy's confidentiality, creating an adverse interest under paragraph 6.5. Adversity exists whenever the interests of two clients are in opposition. This includes litigation, but also simpler negotiations, where one client wants to receive information that the other wants to keep private. Under paragraph 6.5, a solicitor must not act for a client if they hold material, confidential information for another client with an adverse interest. Because Jacob cannot disclose the contamination to Sam, he is prohibited from acting in the transaction altogether. These conflicts also appear when a solicitor acts for both a borrower and a lender in a residential mortgage transaction. If the solicitor discovers that the borrower has overstated their income to secure the loan, they possess information that is material to the lender. The solicitor must seek the borrower's consent to disclose this to the lender. If the borrower refuses, a direct conflict of interest arises. In this situation, the solicitor can no longer act in the best interests of both parties. They must refuse to continue acting for either the borrower or the lender. Large firms often manage these risks by implementing systems to prevent confidential information from passing between different parts of the same organization. Paragraph 6.5 allows a firm to act in adverse situations if they can establish an effective information barrier, ensuring there is no real risk of data crossing between teams. Alternatively, they may act if the client whose information is held provides informed consent in writing. These exceptions are difficult to meet. The firm must prove that its internal architecture is robust enough to prevent any accidental disclosure. It's crucial to distinguish confidentiality from legal professional privilege. Confidentiality prevents a solicitor from voluntarily disclosing client information, but can be overwritten by a court order. Legal professional privilege allows withholding information even from a court, and only the client can waive it. Legal advice privilege applies specifically to communications between a solicitor and client for the purpose of giving or receiving legal advice. Documents do not attract this privilege simply because a solicitor was copied into an email chain. The communication must relate to providing legal advice. Litigation privilege applies more broadly to communications with third parties, provided the documents were created for the dominant purpose of adversarial proceedings that are underway or contemplated. While confidentiality protects a client's affairs from the public, legal professional privilege protects them from the power of the court itself. These obligations remain relevant in the context of the GDPR and the Data Protection Act 2018. Under modern data laws, individuals can submit a subject access request to obtain copies of the personal data a firm holds about them. However, the Data Protection Act contains a specific exception. Subject access rights do not take precedence over legal professional privilege or the duty of confidentiality owed to a client. This ensures that the transparency required by modern data regulations does not undermine the foundational protections of the solicitor-client relationship. For the practitioner, navigating the SRA Code is a matter of applying these rules as a set of specific constraints. Success depends on recognizing exactly when the duty to keep a confidence must stop a transaction in its tracks.